Can landlords deny pets with reasonable accommodation requests? Imagine needing a service animal or emotional support animal to help you live comfortably in your home. Now, picture a landlord refusing that request. What are the rules? Let's find out. Federal law, specifically the Fair Housing Amendments Act, says landlords generally cannot deny pets that are service animals or emotional support animals when a tenant with a disability asks for a reasonable accommodation. This law applies even if the property has a no-pet policy or restrictions on breed, size, or species. A reasonable accommodation means changing rules or policies to allow a person with a disability to have a service animal or emotional support animal to use and enjoy their home equally. Landlords can ask for documentation, like a letter from a licensed healthcare professional, confirming the tenant's disability and need for the animal. It's important to remember that service animals and emotional support animals are not considered pets under these laws. So, landlords cannot charge pet fees or deposits for them. They also cannot refuse the animal just because of its breed or size if it's a service or support animal. However, landlords can deny a request if the animal poses a direct threat to others, causes significant property damage, or if accommodating the animal would create an undue financial or administrative burden. For example, if the animal is aggressive or has a history of biting, that could be a valid reason to deny. These laws mainly apply to larger residential buildings and some types of housing. Small owner-occupied buildings or certain government housing may be exempt from some rules. If a landlord denies a reasonable accommodation without a valid reason, it could be considered unlawful discrimination. Tenants have the right to file complaints with housing authorities if they believe their rights have been violated. For property managers and landlords, this means having clear pet policies but being ready to make exceptions for service and emotional support animals when proper documentation is provided. When a request is made, it's best to act quickly and engage in an interactive process to verify the need and assess any risks or burdens. Denying a request without good cause can lead to legal issues, complaints, and penalties. It's wise to seek legal advice to ensure compliance with all fair housing laws. In short, landlords can enforce pet policies but must make exceptions for service animals and emotional support animals when the tenant qualifies and makes a proper request. Denying these requests without valid reasons related to safety or undue hardship is generally against the law.